Hi, my name is Stephen Lee, and I am an attorney in Chicago who previously was a federal prosecutor and the senior counsel to the Chicago U.S. Attorney's Office's Healthcare Fraud Unit. And I'm very happy to be here today for part two of a two-part podcast looking at Operation Brace Yourself in a real-life case of how lawyers can help their clients through some very difficult circumstances. Now, in part one, we talked about Operation Brace Yourself, how companies responded, and two business owners, owner one and owner two, who decided to shut down their durable medical equipment businesses in 2020 after talking with a biller and a lawyer. Unfortunately, unbeknownst to owner one and owner two, the Federal Bureau of Investigation had already opened a criminal investigation targeting them. Now, I ultimately represented owner one, and I have with me today on the podcast a great attorney, Jonathan Meltz, represented owner two. So unfortunately, the proffer here, owner two's proffer, it clearly did not change the government's view of these guys. And they went ahead and charged owner one and owner two. Jonathan, can you describe the charges and what owner one and owner two were looking at here?
In the end, there was 4 charges I believe we were dealing with. There was a 5th one. They were originally indicted on aggravated identity theft. I think to our credit for being diligent and researching, we were able to convince the government to drop that charge before trial. I don't remember exactly when it was, but at least then that was an important aspect of the case that we didn't have to worry about trial preparation for that particular charge. But the 4 charges that were still part of the indictment as we went towards trial was conspiracy to pay and receive healthcare kickbacks, and that's also known as the anti-kickback statute, AKS. So that's a conspiracy, so it's an agreement 2 or more people to commit that crime. And then they also charged the crime itself, which was payment of illegal healthcare kickbacks. So the actual violation of the anti-kickback statute. And then the second set of charges was a conspiracy again, so the agreement to commit healthcare fraud. And then the fraud itself. They were individual charges of healthcare fraud. Those are the 4 charges. So it's really 2 different buckets that we were dealing with.
But also the key thing is each of these charges have specific elements that the government has to prove beyond a reasonable doubt in order to get a conviction. And that's really important because when you're dealing with federal crimes, especially crimes like this, you have to know exactly what the government has to prove and you have to know exactly what you're defending against. And the key thing for both the healthcare fraud charges and the kickback charges is this concept called willfulness. I think this element actually gets overlooked a lot, but I think it's actually the key to criminal cases like this. Because basically, look, we all know, I think everyone listening to this podcast knows, there are lots of times where people make mistakes in terms of interpreting regulations, in terms of billing, plenty times where people make mistakes. Mistakes aren't crimes. What is a crime is when the government can prove willfulness, meaning that the person actually knew that what they were doing was illegal and did it anyway. Not with the benefit of hindsight, not second guessing themselves years later. At the time, they knew it was illegal and did it anyway. That, I think, is the key thing that often gets overlooked, and it really goes to what the individual person was thinking at the time. So willfulness is kind of this concept that comes up a lot in the kind of cases that Jonathan and I end up doing. And so we want to talk a little bit more about that. So Jonathan, can you give some examples of what are some good examples of willfulness that you've seen?
The most common one I see in a lot of the doctor cases where I represent folks, they're investigated, maybe their records were lacking, incomplete, or sometimes no records altogether. Somebody may go back into their electronic health record system or go into their computer and create records, fake records. For instance, that you, Stephen Lee, went to the doctor last week and was evaluated, you were tested, etc. It never happened. But the individual may put an entry in the electronic health record system, which is troublesome because they're all date stamped and you know when the records were entered, and that creates a big problem for our purposes. Or if it's a computer going in and just creating a document, one of the first things the FBI may do is search somebody's computer, and the forensic search will show creation of all documents and there's a date stamp or there's a trail. So those sorts of things, that shows willfulness, right? Somebody's creating fake records. In the area of, say, kickbacks where there's billing, if there's the creation of fake invoices, without a doubt something was fake, showing that services were delivered, or that there were tests done and now there's going to be billing, or some sort of invoicing is an absolute example of something which was done with a willfulness to break the law. I mean, it's pretty much right, the specific intent to do something the law forbids, right? You're doing it with a bad purpose or to disregard the law. So if you're going to create fake documents, that's a tough order to overcome on our end.
And I think the tricky thing in a lot of the cases that Jonathan and I end up doing is kind of like seeing where is that line? Is it really enough to show willfulness or is it not? Fake documents that are impossible to believe, things like that, I think that is very powerful evidence of willfulness in a lot of cases. When I was a prosecutor, I did have a case once where a doctor was told by a colleague, I think what you're doing is fraud. And he kept doing it. That was pretty good too, but it really depends. And so that's a very fact specific thing. And it really is about the individual person, because the big thing is that it has to be willfulness for that person at that time, not what Jonathan or I or what the prosecutor might have thought if we had been the person, at that moment, at that time, what the individual defendant or business owner or person was thinking. So, and that gets tricky. And basically, look, Jonathan and I, looked at this case, and we both of us thought the government didn't really have the clear evidence of willfulness that the government thought they had. And we think that they rested pretty heavily on some assumptions, which we had to deal with at trial. So one big assumption was that the government, I think, thought that owner one and owner two actually understood every nuance of the anti-kickback statute and every nuance of the Medicare regulations involving DME. They didn't. As you might have heard from part one, they thought they knew things, but they were getting a lot of bad advice from the first biller they were working with. And so they believed a lot of things were actually being done correctly when they weren't. That was one big thing. The government also thought that there was just so much money involved, they must have known that this was improper. That's really in the eye of the beholder, okay, I think. And they did not think that. They did not think that based on their life experience and based on what they were hearing from the biller. Another big thing the government tried doing was talking about customer complaints, because there were customers who complained. But that really, to be honest, that was taken a lot out of context, and we'll talk about that a bit later on when we talk about the trial. And another big thing the government relied upon, I think, in thinking they had willfulness, is they had this one particular audit letter that was sent by the auditor. That was a huge part, we think, of the government's case and why they thought they had a strong case. It wasn't. It was not what the government thought it was. And we'll talk about that in a little bit. But basically, when you talk about willfulness, one of the big issues really is distinguishing between what's actual knowledge and should have known, right? Because you should have known better. That's not the same thing as actually knowing. And it really should be actually knowing in order for it to be a criminal case. One of the big things I think about a lot and is there's this idea out there called truth default theory. If you haven't heard about it, I highly recommend reading Malcolm Gladwell's Talking to Strangers, because that really does talk a lot about this concept. And I think it really helps explain, this whole idea, because I think what happens to owner one and owner two is they trusted the people they were working with. They trusted the biller that they were originally working with. They trusted the marketer whom the biller had recommended. And they didn't see the red flags that were so obvious to the government with the benefit of hindsight. And because truth default theory predicts, and I think this largely holds, that when you're working with people, you generally assume people are telling you the truth. You default to truth. You don't second guess every single thing everyone tells you, because we just don't go through life that way. That's a big problem, I think, because they kind of assumed that they were being told the truth and they weren't. And the government comes in later on, and the government thinks that they knew everything, and they actually knew that everything was a sham when it wasn't.
Quick break. If you're a healthcare provider or an entrepreneur involved in healthcare and have a legal problem, whether it's compliance, regulatory, DEA, criminal, or any number of legal problems, Chapman Law Group is here to help. Please visit us at chapmanlawgroup.com. Click the link below. Now back to the video.
So look, Jonathan and I get involved. We try having some talks with the government. We try to see if there's any way to resolve this case without a trial. Unfortunately, we go to trial. There's no other way around it. It was a long trial. It was 3 weeks, stretching into the fourth. There's a lot going on, but there's a few things that we wanted to talk about here. The first, because again, this can apply in a lot of other cases, is there was a lot of issues involving attorney-client privilege. That's something where we don't get into all the details, but both owner one and owner two, they did consult lawyers during the course of running their businesses. And basically, one of the issues that comes up a lot of times in criminal cases is whether people will waive attorney-client privilege. And so this is something that we had to consider and figure out how to navigate. And so, Jonathan, can you talk about how we did it without talking about what the substance of those communications, how we navigate the privilege issue?
When you talk about attorney-client privilege, it's discussed a lot pre-trial with a lot of defendants and a lot of lawyers. Maybe we could use this in trial, but it's not actually used very much, Stephen, right? I mean, over the years, I've practiced over 25 years. A handful of times have I ever seen it really used. And it's a very, very difficult concept, but it's a very powerful defense for somebody charged in a trial, because if you truly relied upon what a lawyer told you, then there's no willfulness. You didn't try to break the law. You relied upon a lawyer. So it's something that if there's some evidence of it existing, you want to really do your due diligence and try and use it. But it gets dicey in a trial or pre-trial because the government's demanding to see your evidence. We have the rules of discovery in trials in federal court where the government has to give the defense all the evidence which shows that a crime was committed or shows that somebody may be innocent of a crime, right? For years, Stephen, you always turned over, all your discovery, even if it hurt your case. That was your obligation as a government lawyer and totally abided by that obligation. The defense has a little bit of a different obligation, right? If you intend to use something in trial, you do have to turn it over. It's part of discovery. It gets a little different when something is privileged, right? What we talk about with our clients, attorney-client privilege, confidentiality. Everybody's heard those terms for quite a while. And there's a lot of information, whether it be emails, whether it be documents, or things that go back and forth. So in our case, with owner one and owner two, with regard to those lawyers you told the audience that our clients had hired, there was a lot of information that was passed back and forth. And we thought a lot of that information showed our clients were not guilty or innocent. But when you're preparing for a trial, you don't have the obligation to turn that over a year in advance or 2 years because you're not quite sure if you're going to use that defense. You don't have to use that defense if the government's case is so weak, or if you're still trying to convince the government to drop a case. You may not want to turn over what's really the gold standard of it all, your attorney-client communications, right? You don't want to turn that over unnecessarily. So in our case here, the government was demanding, saying, if you're going to use this defense, we want to see the evidence. So then the judge has to balance both sides. The defendant's constitutional rights, communications between them and their attorneys, versus the government's right to know the evidence that's going to be used in a trial. So we did so much research, Stephen, right? All the legal research of how all the courts in the country have dealt with this issue. And it was wide ranging. Some judges said, no, the defense doesn't have to turn it over to the day of trial. Whereas some other judges said, no, you have to turn it over 4 months in advance of trial. You and I were trying to obviously do what's best for our clients, and we were fighting each step of the way to make sure their rights were protected. So I think we struck a balance and were able to have the judge understand the delicate nature of it. And so what we did, we crafted more or less an agreement where we would turn over certain documents which were privileged, so the government had the opportunity to prepare so they weren't unnecessarily surprised at trial or something that could delay the trial, but it was not considered a formal declaration that we waived the privilege. So we sort of got it both ways, right? We turned over the information, but we still reserved the right to decide later at the trial if we were going to use that defense. So that was the balance I think that we struck very nicely.
And I will say, we had a lot of conversations with the government, and the government actually ended up agreeing with us on some of this. I give them credit for that, because they're right. It was trying to find the right balance. And I think we struck it. And then we did actually, or Jonathan, you did something very interesting in terms of the actual trial. I'll set it up. So when it comes to the actual trial, this is a very complicated subject matter, lots of things going on. The government goes first and gives its opening statement. And then I got up and I gave an opening statement on behalf of Owner 1. And I said in my opening statement that Owner 1 is going to testify and he's going to explain to you everything that happened. But I was very careful to not get into the details of that. I did not mention attorneys, because at that point we still had not waived, and we still wanted to see what the government actually put in before we made a final decision about waiver. What did you do when it came to Owner 2?
Traditionally, in every trial, TV, movies, or in person, the government goes, gives their opening statement, and if there's more than one defendant, like we had, the first defendant's lawyer gets up there, gives the opening statement, and the second one gets up there and gives the opening statement. And a lot of times, especially when there's a joint or unified defense theory like we had, the second lawyer will get up and say almost like what he said, right? You're not really adding much, anything different. So it's almost just repetitive. And there's not a lot of a strategic or tactical difference or advantage by doing that. What we decided to do was to reserve our opening statement. So the way that would work is we would hold it and then we would present it after the government was done with all their witnesses, all their evidence, so weeks later. And then we would have the opportunity, if we wanted to, is to give our opening statement before the defense would put on its witnesses and evidence in the defense case. I can tell you that most lawyers, even if they've tried hundreds of cases, right, Stephen, probably have never used it and never seen it, right? That you would reserve your opening.
Yeah, I never saw it. I never saw it before in my time as a prosecutor and as my time as a defense lawyer. I've never seen it happen before. I thought it was really effective the way
it was hard. I'll tell the folks why it's hard, right? So, I mean, you got up there, you gave a powerful, strong opening, basically telling the jury, looking them in the eyes and telling them why Owner 1 was not guilty of a crime, right? And this is after the government got up there and said why Owner 1 and Owner 2 are really guilty of these crimes. And then I'm sitting there next to my client, and it felt like we were shrinking in our seats when we heard the government. And then when we heard you, it's like, okay, great, we're getting a little taller. But then we weren't saying anything. It was hard not to be able to get up there and tell the jury why the government has it wrong and why the evidence is going to show something totally different. But we got through it. And the thinking was this: the benefit of holding your opening statement for 3 weeks later, it's sort of those ideals of recency, that now the jury's going to hear from you. You're going to tell them in an opening statement, you're supposed to say the evidence will show A, B, C, D. It's the map, if you will, of sometimes of what the case is about. So now the jury gets to hear somebody new, somebody different telling them about the case after they've just heard the government's presentation, and it refocuses and redirects or reframes the defense and the issues, right? Because you did a great job, but it was 3 weeks ago. It's like, what have you done for me lately? Now, like, I'm getting up there and we're together, and a lot of times at the beginning of trial, there could be 10 issues. The government presents its case and the defense attorney's like, wait a minute, no, there's only like 4 issues now, right? Because the government failed to put forth evidence for all the rest of it. So now we're refocused, we're reframed, and we're fired up, ready to attack the government's case. So I think, all that being said, it gives you that direct connection with the jury. You're looking them in the eyes now, and you're telling them, here's what you're going to hear in our case, and you get right at it. Whereas 3 weeks ago, they would have to be waiting, and they could even forget what you had said.
Yeah.
So it was, it was really, I'd say, invigorating at that point, because it charged us up. And it's almost, yes, it's an opening statement, but I also call it like a mini closing statement or closing argument, right? Because you're getting right up there and you're basically telling what the evidence is going to be that day, the next day, and then pretty soon after, you're going to give closing arguments for the case.
Thank you so much for watching the video. If you liked it, please hit that like button. It helps the channel. It tells YouTube to show this video to more awesome people like you. Hit that subscribe button and the little bell to the right so that you get notifications of more upcoming videos.